Eva, how are you? Call Eva. Ask her to start. Maybe it is on. Okay.
Now, we have no, I will have clicked your thing. So now I start the sharing. I join the meeting. Huh? Okay.
Okay, good morning. Yeah. Good morning. Let's wave one another namna hii nione. This is the third day of the training, and I'm very happy that you've persevered to be here for the 3 days. I don't know whether our kids have left or they are still sleeping or they are still registering. Can you check out there? You see whether there are people outside, so that I guess we've given them enough time, is it? And some of us are traveling. I've written request. Watu wanataka kutoka waende very far to the other end of Kenya. But if you choose to disappear before the day is over, ensure you have enrolled. Otherwise, utakuwa missing from the attendance register. My name is Dan. Team Dan, where are you? Mko wapi? Yes, you see that is my team. And then is D-E-N, not Ben. but I usually tell people my name is Dennis to avoid them calling me Ben. Then, if you are wondering what I want to do, I guess that is true. At the end of every training, you need to access your certificate, is it? Ni kweli? A certificate is a prima facie evidence that you attended a training. Now, but before we do that, today, yesterday, I guess we covered so many topics: the employment and labor relations code, the case studies. So I will use some few minutes of her time because she wants to do a recap from day one up, yeah, before the next person completes on our program. I needed to take you through how to access your certificate. Watu wa Thika Water, Iwaso, where are you? Is it possible for you to stand where you are? Why don't we clap for them? Before they sit down, is it possible to say your name very fast? What you do, then na unapeleka mpaka sanitizer? Yes. You will see the people, so I know everyone by name. Just what? Microphone. Oh, very good.
Good morning. My name is Albert. I am the head of the
Good morning. My name is Naisera Wairimo. I'm the head of security.
My name is Roy Nelson.
Hata mkiambiwa good morning, mnasema good morning. Ili pia nikikusimamisha, ukisema good morning, you do not keep quiet. Haya.
Good morning. My name is Roy Nelson. I'm the chief steward.
Nelson is the chairman. Ukisema unakaa chini. Nelson is the chairman, the shop steward. Niye wa kusema comrades power. That's very good. Haya.
Morning. Names are Cameron Michelle.
Very good.
Good morning. My name is Suse Kalume, Director, Diwato.
Very good. Just the way.
I'm Jane Gashiri.
Morning. David Moore, Wako, Sabatua. Very good. At the country note, this is a roll call.
Morning. I'm Mori. I'm a steward. Morning. I'm Joseph Tuguna, payables accountant, and also substitute.
Very good. Hatuko wengi. 5 minutes we are done.
Good morning. Anjambi, Mtaza Vice.
Very well. Let's, okay, there is one small hit there.
Good morning. My name is Elaine Wanjiko, Corporate and Legal Affairs.
So let's give a big clap for Thika Water. They had a delegation of 16 participants. including the managing director. I've talked to him this morning, but he's attending to some business later. Now, I want to ask the team from the National Treasury to start, the National Treasury. I remember, I know the number of every group, so this is a roll call. So I expect 8 participants from the National Treasury. So 3 are absent. No, 2. Very well. Let me start with the lady in the front. Again, this is the reason I'm asking you to say something. We are the only academy in HR that gives opportunity for people who wish to train, a platform to do training. Like as I'm speaking, and that has reminded me something. I must be making a lot of noise to some people.
Hi, good morning. Participants.
People care.
Eva.
Morning breakfast. When I get good listen.
Why are you not sharing?
Hello, good morning once again. I hope we are clear now and you can get the sound and the visual. This is our final day, our third day for the training. It's been a 3-day journey. It started on Monday, and we're going to start, we're going to have a session today, and then we're going to go for a short break. We'll come back and then we'll have another short one and finalize. But before we even start with what we had today, it is good to have a short overall recap of how it's been from the first day. I know many of you had mentioned that you'd like some small recap of what had happened, especially on the first day, what we did. So it will brief in some few minutes. Let's do a recap together and come all of it. I'm here, I'm Eva Magiri, and I'm also here with
Hi everyone.
Now today let's do a very short recap that is quite short but comprehensive. On the first day, we had a very good coverage of the labor laws. And we got an overview of what are labor laws and all that. I don't know whether one or two of you can just session of labor law. I want to invite at least one of you to tell us something they remember and it made an impact on them on that session of labor laws. Kindly feel free to share or to give a recap of what it was for that session. Anyone? Okay. Anyone who wants to come in and tell us something they had an impact on them on the session? Maybe we can, I can start you off. As you remember, we had an overview of some of the four labor laws. And we said, what are some, if you were to list some of the labor laws? Okay, let me start you off. I don't know. I hope it's not, you're able to talk back. It's not like yesterday. I have seen your chat this morning, and I hope you're able to talk back. In case of any anomaly, kindly share in writing. But I hope all the issues are good. So now let me take you through as we sort that one out. We got an overview of labor laws. First, we said they are associated. We saw how they come from all different places. And one of the key places we saw was from the Constitution, as we know it. We talked about the judgment, proceedings, and current hearings. We saw something we called common law, that if something is happening and it is a culture, what you can say a culture of a common occurrence, it can be quoted and it can influence the outcome of a judgment or a case. And cases of law. And here we gave an example that maybe if at the place of work, every time you do a painting and you are given a packet of milk, then the employee will always expect a packet of milk at the end of the day. So there's a dispute, and then the milk is stopped because of other things. He said that the practice should be called common practice, that it used to happen, and it can be based for future judgment. We also saw that we inherited the British law, and so the law as it was before it came to independence is a good source. Then we also said Parliament makes laws. We call them acts. They are bills, like what you do today. On your screen, you can see there is a bill. We are calling the Employment Act Amendment Bill. That's an example. So they are bills that eventually, when they are passed, and the signature, the presidential signature is appended upon them, they become full acts, and they are the legislative and sources of the law. Then after that, we went on the same day into contract, and we had a very good discussion about. Yes, I can hear. Hello. So it seems my sound is coming out muffled. That one is being sorted immediately. So I hope now the voice is not muffled. It's more with reach the second thing.
Hello, you are now, your voice is, you are not hearing you at all.
Hello, dear participants. We made some changes that has made the issues more stable and resolved. And we continue immediately from where we left. And once again, we are very sorry. So we were discussing and we were having a recap. So we had talked about the contracts, and apart from the contract, we had rights and obligations. And we said everyone has their rights, employers have their rights, employees have their rights, and each one of them their duties that they expected and obligations. And this is in all matters, including at the workplace, responsible representation outside of the organization, and all that. So that was in the second day. After that, the next day, we went and did termination and dismissal. We discussed quite at length issues of termination. We discussed at length issues of dismissal, types of termination. And we saw that the various types, each one of them should be based in the law. And we saw what amounts to fair and what amounts to unfair termination. Issues of discrimination came out. And maybe some examples I can give you to revise your brains. When we came to fair termination, what are some of the things we said about fair termination? Firstly, you are not willing, the duties you've been given, you're not willing and able to do. Maybe you came to work intoxicated, and so you're not able and willing to do this job. Number two, you're not at your workplace and workstation without any valid reason, and you had not communicated to anybody the same. That is the second one. I have given you two of them. I want you to give me some three or four. What amounted to a fair termination, or what do you remember about fair termination? Please, kindly let's interact. It was quite a lengthy presentation. We discussed the whole day, termination and dismissal. Tell me something that you remember from it. The sound is clear now. I can hear you, and I would like to hear what you have to say. Any feedback on fair and unfair termination or any other issue touching on termination? It's also good. Yes, Vivian.
I'm sorry, I didn't have a very good night's sleep.
Oh, sorry for that.
So I'm not as alert as I would like to be.
Don't worry, it happens.
So I'm jogging my memory.
Okay.
Fair termination means that you have to observe you follow due process.
Yes.
You make sure that the law is followed. I'm not remembering too well, but I think it's partly because I'm a bit fatigued.
Okay, don't worry. So So then you are very right. The Employment Act says that if any of the provisions were not followed during the termination, then it was not fair. Then there are three things. One, there should be a valid reason, a fair reason, and also the procedure that was followed. There could maybe a valid reason. Maybe the termination was fair, but the procedure that was followed was not fair. So it makes the whole issue very complicated. So that is one of the topics we went into. And we saw so much sometimes. For example, we talked about redundancy, we talked about summary dismissal, we talked about issues of surrounding retirement, and even yesterday we went ahead and discussed voluntary retirement. So that was during the second day. Yesterday also, we tackled a very interesting topic, which was about ethics. And we asked ourselves, why is it important to train ethics in the context of labor and industrial relations? And we saw that ethics is important both for the company and the worker. So could any of the participants kindly share with us some impact that the session had on him and the issues at least that he or she can remember around ethics? Anyone who wants to try? There is no wrong answer in an adult class. All answers are right. What do you recall about ethics? And you know, ethics covered all issues, including corruption, include whistleblowing, include sexual harassment, which was quite an interesting topic. And we covered it with our trainer, Agnes. And what are some of the issues you can remember from that training?
The one thing that stood out for me is that you shouldn't remain silent if you see something go wrong.
Okay.
Yes.
And we all have a responsibility, because if you look well, both the company stands to lose, and we stand, and also employees stand to lose. And some of them carry a criminal tag, that there are some violations that can see someone in jail, or even ourselves if we are not free. Then after ethics, in the afternoon, we started to apply all the knowledge that we had learned, and we did it through going through some cases. We sampled quite an elaborate list of cases from all sectors: the hotel sector, banking sector, manufacturing, and it brought out all kinds of issues, from a process of termination, from foreign contracts, from sexual harassment, and we saw some of the impacts and the rulings of the court. And in this session, we were very lucky, because we were graced by an advocate at the court who practices this and gave us quite some insights. And we all learned a lot, including myself, and I know it was very enriching. So today is a new day, and today is our last day. And I know as much as it's summative, we are also going to tackle something called an amendment bill, which is the Employment Act Amendment Bill. It is good to know what is coming as partners in the workplace, how it will impact on us, so that we have an overview of what to expect, and also why. Maybe from some of our discussion, we could question there may be some provisions of the Employment Act. So it is not as maybe this has risen over and over the years, And after some time, since 2007 is quite 12 years ago, things have changed. Even the workplace has changed. The players have changed. For example, the workplace has changed. Players have changed, and even the employee. There are many. There is a diverse. We now have all diverse group of employees, and even the act and even the labor provision felt it is good that it encompasses this. Another reason why it was good, maybe, or those who saw or proposed an amendment to the Employment Act, is because once we got the new constitution, there's a name I can't say there, promulgated. Once we promulgated a new constitution in 2010, then many other things had to be aligned. For example, I don't know whether you realized when you were learning all these laws, we kept saying the minister, that's to go to the minister. Yet we know they are no longer called ministers, they are now cabinet secretaries. We have provisions like the armed forces. Before there were no armed forces, it was just a blanket. The National Police Service was not there. So in the act, like especially where it is exempting people coverage, you see names like police force, military, all the terms that are no longer there because of the new constitution. So that is one of the reasons also that has informed this. So as I had informed you, we are going to go on a journey to have this review. It's now 9:51. Let's have some review of the bill. Then we go for a short break at some time. Then we come back and then we finish and see how the Amendment Act has been amended. Then we also want your reviews, your feedback, and some kind of overview of many other issues or any other outstanding issues, both from the recap session, the issues I've reminded you, and today. I'm with me, my colleague Omondi. The first thing I want to tackle that is going to change now with the new law, once it is, remember it's a bill, it's still being discussed. There is a lot of lobbying taking place. There are people who are lobbying because they don't want some provision. There are those who are lobbying to have some things included. And even as the process continues, before it becomes an act, these are some of the provisions that have stood out. The name of the bill is Employment Act Amendment Bill 2019. One of the things it's tackling very well is issues of casual employee. Let's go back to what is really a casual employee as we know him or her, and some of the things that are attached to him or her in the current law. The law recognizes a casual employee as that person who works and is entitled to his pay at the end of the day. That is number one. And number two is that he's involved in 24 hours and not more. And then it is continuous. Maybe if you call a consultant or somebody to do something once to paint, don't need to paint again the room. Maybe it will come again next year or 2 years down the line. So it also has to be continuous. It's work they come and do on a continuous basis. They receive a pay at the end of the day. That is one thing that has come out about a casual employee. Other issues that have described casual employee is even some exclusion, maybe like under itemized item, but there was a mirage somewhere. If you can remember, there are people who come and they are paid based on the work they have done. For example, they come and pick the coffee or pick the tea. And then when they finish their bag of tea, they are paid based on that. That is what we had been referring to as the piece rate work. So, well, is it casual? They are being paid daily and they go? Yes, they are being paid on the quantity of the work they have delivered, not on a fixed rate at the end of the day. So to remove this mirage, this bill has done something very well. And what it has done is that it has clearly stated that casual employee excludes the piece rate work. So the piece rate work is going to be defined separate from the casual employee. There's also an issue of foreign workers. In our organization, we have some of our colleagues who are nationalities from other countries. So there is a whole section of the Employment Act that guides on the issue of foreign employees. But before they would come and there was no clear, they would come, they look for work permits, there was no clear guideline, they would go to the ministry. The law says that when you're doing their contract, you had to engage the labor office. There was no clear cut what comes first. But now the bill wants to set the path clear, what comes first and what follows second. And some of the issues is that the foreign employees must first come, they are regularized with their Kenyan citizenship as the law that guide immigration states. The Immigration Act, they comply with it, and then once they comply on it, now they are able to engage in employment. This is to align the Employment Act with issues where you find that workers come sometimes on tourist visa. Somebody has come on tourist visa, but if their main aim is to stay and then after some time work it out and get themselves into employment. So maybe those who had lobbied and proposed for this provision of this section felt that the other acts that control labor should also be tightened as good as those that constrain immigration. So those who have employees that are working and are coming in and are not residing, are not nationalities, please note that this is a proposition that might later come to be implemented once this becomes an act. Then we have grounds for discrimination, but there's something very important I want to say here on foreign employees. In a nutshell, it means that someone must have a work permit before they are engaged in employment. That is what is being proposed in the bill. So they must have a work permit before they start working. Another thing is we've been looking at discrimination a lot, issues of discrimination. And what does the current law say? There is don't discriminate based on gender, based on age, based on what else? Based on what else, participants? You cannot discriminate based on sex, based on age, disability, issues of disability, HIV, which one? What else? Vivian, you have an idea? There's quite a list of things that
there's age, race, gender, marital status.
Yes. Now, that is quite interesting. I love that you said marital status. You know, Vivian, that's a very interesting one because one of the things that is being proposed to be included is actually marital status. If you look at the bill, it says after pregnancy, there is no marital status. marital status is coming now in this new proposition. So it is talking about the race and all that. So it is including the others. First, belief. Now here, maybe we can have a brainstorming session because it says belief, but it is also not clear what is this belief. Is it religious belief? Is it political alignment? Just says belief. And this is some of the discussions that are going on. What is really belief? Then also culture, dress. You should not be discriminated based on the dress, how you dress at the workplace. Then also birth. Now that part for birth, it's quite interesting. Now, Omondi, can you just spend a minute and tell us what is this birth? Is it you being a firstborn, a secondborn, or what exactly is this birth? Just in a nutshell for 1 minute.
Good morning, everyone. When you talk about birth, it means that you may have been, it refers to sexual orientation. You have been born as a male child, and you want to convert to become a woman, or you're born a female and you want to become a man. There are those people who go through sex changes. So their identity essentially changes. Now, the law as it is today, these people are not able to change their names. So if you're born as Vivian and you have changed your sex to become a man, you cannot change your name to George, for instance. So you lack the necessary documentation, your certificates, and your gender are different. You look at other areas where these people are discriminated based on the facilities. There are people who are transgender, and when you go to places of employment, you find they do not have adequate facilities to cater for them. They don't know whether to go to the male washrooms or the ladies' washrooms. The same happens when they are in police custody and all that. So these are the things that, in terms of employment, this law is attempting to address. Okay, thank you, Eva. You can proceed.
Okay. So I hope you've understood the meaning of birth. Let's continue. Now, there was something we mentioned yesterday when we were talking about the hospital, and that is the fourth thing that will come up with this new Employment Act. And this is being called non-compete clauses, or what are called post-termination. Let me jog your minds yesterday. You remember there was a case where the employee was told, and it happens in some of our experiences at the workplace, that if you work for company XY, tomorrow if you are terminated, then company XY expects you not to continue practicing for the next maybe 5, 3, 4 years. Now, the argument of this new proposal is that even the company XY, they took you because you had prior knowledge. They took you because you have experience. When you are applying for a job vacancy, they always told you must have 10-year experience. So it is quite a clash of guidance that once you leave, then you are not supposed to take your experience somewhere. And so those who have been lobbying for this provision, and the provision is already in the Act, and all the players in the labor sector are discussing it, is that these post-termination provisions are going to be null and void. They are going to not to stand, and they are going to be unlawful. Once you leave a firm, that firm cannot direct you on what to do, where you go. I don't know whether you remember the ruling that came out yesterday from that example I gave you. Remember the court said that then that person, if the company does not expect the person to continue working, then they should pay that person for that period. So if company XY does not want Eva to continue working after 5 years, then they should continue paying me for 5 years. The second thing that the court said, remember at that time, is that there is very high unemployment in Kenya. So we cannot have people who are not working because of many other constraints. So that's a provision that will be captured in the new law. I hope you are together, participants. Let's continue. Now, we saw sexual harassment yesterday. And you remember we said if you have 20 employees, you must have a policy. And that policy must be well written, hanged somewhere everyone can access, not hanged uko nyuma ya store, when the auditor comes, you saw that is the sexual policy. No, the policy say it should be hanged where everyone is accessing it. And then it should be in a language, or it should be understandable to everyone at the workplace. Now, the new bill has changed. It has changed from 20 to 5. It is proposing that you don't need 20 employees for you to have the policy. You only need 5 staff. Now, why do you think it was important to reduce from 10 to 5? Anyone who has an idea, what was in the mind of the good people who came up with this provision? Why did we move to 20 to 5? That's very good. Night Nzovu tells us, hi Night, I hope you are having a good morning. Now, Night is telling us that we have staff in small organization also getting harassed sexually. So they need to be protected. Excellent. That is the exact reason. Sexual harassment is happening everywhere, including at the workplace. And there's something very interesting also the bill is trying to do. There is a mentality, or there is a packaging that the sexual harassment is only happening to the employee, but it is also bringing in the employer. So even the employer is captured on issues of sexual harassment. It is not an employee thing, but also an employer. And it even adds, where you only have the word employee, it also adds an employer. So that issues of sexual harassment don't just seem to occur, only to employees. So now if you have a small bakery, you'll be making your bakery, and then you make a sexual harassment policy and you hang it where your 5 staff can be seeing every morning. So thanks a lot for that, Night. That was right. Let's continue. There is also an introduction on new issues surrounding payment and overtime, night work, and issues of flexible working time. This is very interesting. Let's discuss it before I invite Omondi to discuss with that one more issue. When we give, or at the workplace when we receive what is called itemized payment item, ile tunaitanga payslip or your breakdown of your pay. There's a new guide in this bill on some of the things that should be included there. The bill is saying, for example, if you're being paid overtime, your pay slip should break down overtime for daytime and overtime for nighttime. So it is saying that the breakdown should be elaborate. The nighttime should be elaborate on was it overtime for night or was it overtime for day? I hope the slides are now more clear. Kindly, if you have an issue, raise it again. Thanks a lot for that. Okay. So give us 2 minutes to work on that. Thanks a lot, Vivian. Slides are black. Then we do that. So, ladies and gentlemen, I'm proposing that because we are to go for a break in 10 or 15 minutes, we go for the break now, then we fix the issue and we come back at exactly 11. We will have fixed all the issues comprehensively. Then we go to the bill deeply and evaluate everything. Kindly. Hi participants, we are back to our session, but as we start, I want to brief you that our technicians have worked on the issue, and we've resolved that, we've realized that the issue is not localized. So we'll proceed with the slides as they are, and I'll try my best to be as elaborate as possible to compensate for the visuals, because the problem is not localized. That's what the technicians have established, and we are sorry for that. And now that we are back from our break, let's continue. Hi, Vivian. So let's continue now. Bear with us because of the slides, but bear with us because of the slides. It's now been established that the issue is not local. I'll compensate for it, as I've said, with being maybe more elaborate. So we had reached the point of introducing payment details on overtime, night work, and flexible working time. I had told you that the new law wants to put in place where that someone's payslip can show the breakdown of exact nitty-gritty of what entailed maybe overtime, night work, and I'll also explain exactly what is flexible time. So it means once this new law comes into force, you will be listing the particulars of the overtime. Was it done during the day or was it done during the night? Then another thing is that the workplace is changing and there are many emerging issues. Issues like working from home, we have seen, has really gained momentum. And maybe even when the bill was coming, all these were not in place. But there were many dynamics. For example, if I'm at home and I'm delivering the work, I'm meeting my target, what is the whole, how do we capture the whole issue of the amount of time and all that? So it has entailed that flexible work should be encompassed, the time spent not at the workplace but doing office work should also be captured and included in the payment. So let's continue with penalty. And this is penalty for wrongfully withholding or deducting employee salary. Now, let's first look at the background of wages as they appear in our current law. Our current law protects wages. There is a whole section it calls protection of wages. It shows how workers should be paid, employees should be paid, the manner in which, and the time. Let me give us a few examples. It says that payment of wages should be done during a working day. The law says that it should be done within the premises of which the workers are working, or with agreement with employer, it can be done elsewhere. It also said it should be done in a certain open way, and the workers should be given an itemized item. There should be no coercion or withholding of the wages so that you fulfill maybe certain conditions for future employment. Now, previously, if you withheld if an organization withheld workers' salary, it doesn't pay them. Or you get a situation where deductions are made, maybe to the social security body, to NHIS, to all this, but the same is not remitted. Maybe it is for a certain fund, it is not remitted. The current law says that such an organization, if one is found guilty, is culpable to a fine of 100,000. However, what the new law is proposing is that this now will go all the way up to 1 million shillings. So if an organization does not pay or withhold, but it uses a very interesting name. It uses the word wrongfully. So this is what it says. Let me read for you. The penalty for wrongfully withholding or deducting employees' salary will be 1 million Kenya shillings. So in brackets, this is up from 100,000 shillings. So maybe this is a deterrent clause to deter and mitigate cases of people working at not maybe receiving their income due to deliberate and wrongfully. Let's go to the next issue. And before I discuss this issue, I want to draw an example from the supermarket sector. In the supermarket sector, sometimes you see mergers. Sometimes you find maybe one stream of supermarket maybe has closed and it has handed over and another one has opened. Now, sometimes in the current law, those who are working within these streams or these different sectors, like the example I have given, you find there is no clear-cut guidance, both to the employer, what to do with the current employees, and also to the workers, what is going to happen to them. Our employer is going, and now we are being handed over to a new employer. What will happen to us? At the same time, the employer is not guided that now I am leaving my workers and I'm going and I'm leaving them to a new organization. What exactly am I supposed to do with them? So the new law has envisioned this gap, and it has come up with a provision that it wants to fill this gap. So let me read for you before I explain. It says, introducing rights of employees in transfer of undertakings, novation of employee contract. That means the rights of the employees, everything that they used to have will automatically be duplicated in the new establishment. Better, but not worse. That means that the terms will continue, but maybe the new organization may want to better them. However, the rights, whether in terms of payment and other benefits, cannot be reduced and they will be transferred to the new organization. So that is what that clause means, novation of employee contract. So if your organization is you're leaving the organization and it's going to be taken over, like I have said, you have seen a supermarket close and the same supermarket is taken over by another one. Because the previous supermarket organized for this other one to take over. That's just an example I'm doing. But many other organizations will see the same, do the same. So please note that all the rights that the workers used to have in the former organization will now be transferred to the new organization. The other provision is what the issue of non-disclosure. When you think about non-disclosure, you think about keeping secrets. You think about signing an agreement or agreeing that I will not keep in the secret of this establishment. So this new clause is saying that when people are in a certain organization, they are bound by non-disclosure. They are said that they will not reveal the secret of the organization, especially once they leave. They cannot go and say what was transpired in this organization. But if it's issues of trade, it is issues of business and all that, it has introduced something very interesting. Let me read for you before I explain. Non-disclosure clause will be allowed for a reasonable period. That means you can keep secrets for a certain time. Now, I don't know, here there is still very stiff discussion because exactly what is reasonable. I think you and me, we can challenge each other. What exactly is reasonable? And this being a legal document, maybe the final act will polish some of these things. And it says that you can keep the secret, you can continue, but for how long? Is there a time that comes that you can now go and implement or reveal the wealth of knowledge that you used to have? So the non-disclosure clause is not coming out clear, and the use of the word reasonable, maybe there is no clear definition. What exactly is reasonable? 2 years, 10 years, and maybe before then the clause might be changed or come out more clear. So, ladies and gentlemen, let's continue. And before I say much, I want to pose something for you think about. In the current act, when you get a baby, you go on maternity and paternity leave. What about parents who are adopting children? It's also new babies, it's also new children. What happens to them? I don't have a child and I would like to adopt one. The law does not have provisions for that. So now that is going to be introduced, that when a parent gets a new child, they are going to go on what is called adoption leave. But please take note, the children are below 2 years and it will be for 1 month. So let me read for you again. Adoption leave for children below 2 years will be 1 month. So if you adopt a baby, you will be going for what is called adoption leave, just like maternity leave and paternity leave. So that is clear. Let's see how we are progressing. Now, just within the same environment of maternity and paternity leave, remember the issue of paternity leave has been for 2 weeks. And I want to share with you something very interesting. When there was lobbying and advocacy being done on this bill, there is one group of the lobbyists who are saying that if maternity leave is 3 months, why are the men being given 2 weeks? Even them, they want to bond with the baby. And a lot of lobbying went through. And that is why issues of paternity have formed part of this bill. And it came out differently. And this is what it says, that paternity leave should be preceded by a birth notification in accordance with the law. So the 2 weeks are not touched. But it says now for one to go on paternity leave, they must give a birth notification accordance with the law. I want to pose a question to you. If I get a baby and I go on my maternity leave immediately, the provision is 3 months unless it has been improved in our CBAs or collective bargaining agreements. But what happens if my baby dies or I get a stillbirth? That question has been arising over the years. I've gone on leave, but I got a baby and I lost the baby. So what happened? So the same has been captured in this new proposed bill. And that is what it says. It says maternity leave is limited to 1 month in case of a stillbirth. So if you go and maybe unfortunately you lose the baby, the maternity leave is 1 month. Here it's maternity leave. The paternity leave is not reflected in this particular provision. So the mother goes for a 1 month maternity leave, then comes back. Sometimes when we were implementing the current act, I have seen organizations try to compensate for this and support the worker by being innovative and using any other provision. I saw some use the term compassionate leave, and they could send the worker for a compassionate leave. Some could write sick leave, and we all tried to be very innovative to justify this. So maybe, I don't know your comment, but I feel that it could be a good move to have it very clear in the law that stillbirth, you go for 1 month maternity leave. Let's continue. We have seen mothers who adopt. We have seen those who unfortunately lose the baby. But there's another very interesting arrangement where maybe Eva cannot get a baby. So she has opted to have another lady carry for her a baby, what we call surrogate motherhood. Now, that lady is going to get a baby, but I'm also going to get a baby. So who is going to go on leave? Maybe we can ask ourselves that. Who is going to go on leave? I want to hear your feedback before I tell you. Vivian.
I personally think that both should go.
Who? The one who receives or the one who gives birth?
Both of them.
Both of them. Okay. Vivian feels that both of them should go on leave. Anyone with another contrary view? Anyone who feels different? Feel free also to use chat. Okay, let's see what the law says. Vivian says both of them should, because baby one is receiving, is a new baby, and the other one is has given birth. So this is what the new law says. Surrogate motherhood entitles commissioning parent to 2-month parental leave. So our brother Ronald will come and tell us about the commissioning parents. I want to leave that as something you think about. Who is the commissioning parent? Now in layman, not in legal terms. Unajua hii legal terms. In layman's Vivian now, umesema you think both. No, who the commissioning is which one? Can you explain to a layman?
The person who wants the baby.
The one who wanted the baby. Okay. So Ronald Vivian says that the person who is receiving the baby is the one who is going on parental leave. Is she right? Yes, come. Let's hear from, we are lucky the advocate is back here. Can you tell us this jargon, commissioning parents? We want to brainstorm, and Vivian is commissioning that both of them should go on leave. And I know there was a lot of lobbying around this. Can you tell us what is commissioning? Is it the one receiving or the one giving? So Karibu in a minute and explain to us.
Good morning. Hi, Vivian. Okay, what happens?
Hello.
In our country, we do not have specific laws that cover surrogate motherhood. So it is also a new area of our. It's also a new area in our jurisdiction. We do not have surrogate motherhood that is covered by law. In the same way, we do not even have things like gender reassignment. So even the people who have gotten children over the last 5 years, there are several people who gotten children through surrogacy in Kenya, but all of them have had to go through an adoption process, because what happens is that the mother, the person who actually gives birth to the child, by law is considered to be the mother, and that is the person who is given the birth notification, and they're the ones whose name will appear on the birth certificate, because they're the ones who've actually delivered the child. So what happens is that they now have to formally adopt the child from the surrogate mother. Now, because of that, it becomes a very tricky situation, because we do not have any laws that govern this. So as an employer, you might find yourself in a tricky situation where both the commissioning mother and the surrogate mother are your employees, and they could even be in the same department. So one of them will genuinely apply for maternity leave because they are actually expectant, and they will bring you the EDD telling you that this is my expected date of delivery, so I need to commence on maternity leave. And you'll have now the other mother who is the commissioning parent. And you find yourself in a tricky situation because you have got nothing guiding you by law. So as an employer, you have to be innovative as per now. But what the bill is proposing to do is now to give law that will be able to guide you on how to proceed. So such that you do not have to clutch at straws in the air and try to think of exactly what to do. So this bill proposes to give you as an employer an easier time in the event that you come upon such a situation. And I believe also when this bill is coming into play, there'll also be a certain other amendment to the law that will recognize surrogate motherhood. So at least they will go hand in hand, because you cannot give on one side and an activity that is still illegal, that is not recognized by law. So this bill caters to.
You can see even in the bill, some issues are still not very clear. This is also another one. Remember the other one maybe said about belief, not clear what they say belief. And also remember the third one, we said about reasonable time. I don't know what time is considered reasonable. And maybe by the time all this is now becoming a full act, some of these things will have been sorted out. So I wanted that discussion so that you can get a clear view and you can see it's been brought out very well by our wakili. So let us continue. We give many statements. We give, when people leave employment, we give them all manner of letters, maybe the employment letter, we say how they used to work. But now there's also an extra provision. What happens to those who are dismissed? What happens to them? So let me read what is provided. It says that employers to provide an employee with written statement of reasons for dismissal. So the moment now you have formally dismissed somebody, maybe summary dismissal, go home. You must give a written statement of the reason for dismissal. So this was not captured anywhere before. The employer was not said anywhere that they had to give any written statement for dismissal. Vivian, I like your question. You're saying you have a comment that considering the times and seasons, might the bill still need further amendment? The process is still on. What I can share with you, participants, is that there's a lot of lobbying going on. Before this becomes an act, before even issues of tabling, before anything, there's a lot of lobbying going on. And these provisions you're seeing, at the workplace, we have what we call the tripartite. We have the employer who has a federation, we have the workers who have an umbrella body, and we have the government. Now, all these partners have various issues they would like captured, and they are in what we normally call in industrial relations social dialogue. They are dialoguing, they are debating, they are lobbying, and I know many of these inclusions will be captured in the bill. And that's why there are many issues at the workplace, but these specific issues have formed part of the act. Because even as we were implementing the Employment Act, we were realizing there are gaps, and we are trying to fill these gaps. At the same time, I told you, the workplace is changing. There are emerging issues, like working from home. We are trying to accommodate that. The new constitution, I don't know whether it's 20 years, but in 2010 we had a new constitution. We are still not calling in the Employment Act, we are still referring to minister. So these are some of the needs that arose that maybe it was time for a new Employment Act. So Vivian, you are right. Maybe by the time they'll still be lobbying and the process is still going on. Another interesting thing is on education. We have been having workers, employers debate, and they want maybe to empower or further their education. Maybe when you got into employment, you are undergrad, now you want to do your postgrad. And what do? You normally apply for education leave. Mostly this is guided by the workplace policies. There is no law to guide it. There is no law that pegs the employer to give you the education leave. It is on goodwill. But now the new law is introducing an education leave. And this is what it says. Let me read for you. Introduction of education leave of 10 days per calendar year. So in every year, that person can, if they want to go for education, can go for 10 days and have, do maybe go for a training, go for something and come back empowered. Let's go to issues of sick leave. In the current environment, the sick leave has not have what I would call a time frame guide. But at the same time, I want us to be very keen and very careful. The current Employment Act actually repealed the previous law. But the same law that was repealed had a stronger provision for sick leave than the Employment Act 2007. I want us to walk very slowly here so that we understand where it's coming from. So the law that went had a stronger provision than the law that came in. And then the same law said that in any other law or in any law where the new law is weaker than the current law, then that other law will stand. So it meant there has been confusion because at one point we've been told to throw away the old law and we are implementing the Employment Act 2007. So the new amendment now wants to capture the old law the way exactly it was before 2007. And this is what it used to say. Sick leave will be at maximum of 30 days with full pay, then 15 days with half pay for all employees in a year. So first you can go for a sick leave of 30 days maximum and you are being paid fully. Then you've not recovered, you continue with another 15 days where you are being paid in half. And then it has included something it is calling all employees. And then the time frame is in every year. So let's be clear on that. So remember at some provisions we were saying the law was coming to fill some gaps. So here it is coming to fill that confusion, that if that law was stronger, it will stand. And then again, it is repealed. So many of us actually closed that law and we took over the 2007 law. But now, the confusion might be put aside now with the new bill. Now, I would like to invite Omondi, Rono, to explain more on that.
Thank you very much, Eva, for that explanation. Now, what has happened in 2007 when the employment laws were changing? One of the things that happened is that there was a regulation of wages and conditions of employment act, that was CAP 229, that was repealed. But this CAP 229, as much as it was repealed, the subsidiary legislation under that act was maintained. This is where we have the general order and all other industry orders like the timber, the hotel order. So there's been a lot of confusion as to what sick leave is supposed to be. So the Employment Act indicates that an employee is entitled to 7 days full pay and 7 days half pay when it comes to sick leave. On the other hand, the general order under the Regulation of Wages and Conditions of Employment Act, which is still in place, provides for 30 days full pay and 15 days half pay. So what this bill is intending to do is to harmonize this, because what has been happening up to date is that the law always looks at the provisions that are more beneficial to the employee. So employers who actually know about the regulation or the general order under the Regulation of Wages and Conditions of Employment Act, implement the 30 days full and 15 days half. So what this bill intends to do is to ensure that to marry these two provisions such that the Employment Act will now read what other subsidiary legislation is, so that the Employment Act now will provide for 30 days full pay and 30 days half pay, so that we do not have that confusion anymore as to which law is superior to the other. Thank you for that.
Thank you a lot, Ronald, for that. So I know now that it's very clear. Let's proceed. We've seen we are giving written statements for dismissal, but you also give various certificates, certificates of achievement, certificates of all that, especially when people retire. We want to appreciate their long services in the organization. So the Employment Act is therefore proposing that those who go on employment, they've been in employment for that long, that once they go and retire, they should be given certificate of retirement. So it is very clear. Let me cite it. It says, certificate of retirement to be issued to retirees. So those are some of the propositions. Now, we have a very nice question here from Ann Rita. Ann Rita is asking, what's the relationship between sick off and sick leave? Wakili, what is the relationship between a sick off and a sick leave?
Sick off and sick leave are they both mean the same thing, because it is just a question of duration. Because when it comes to sick off people, mostly employers and employees, interpret this to mean that it is just 1, 2, or 3 days. While sick leave, the regular meaning that people refer to it will be a longer period of being away. But the basic thing is that they are both days when an employee stays away from work because they are unwell, either due to injury or due to any other ailment that they may have. So when you have a policy that says that employees have got 30 days sick off on full pay and 15 days sick off on half pay. So when this employee takes 1 day sick off, it is deducted from the sick leave entitlement they have in a particular year. And you go reducing that as time goes by in a particular year. So this sick leave is not like any other, and sick off are not like the annual leave that have to be exhausted. You have employees who may, luckily enough, they might work 5 years without even taking a sick off day. It does not mean that leave accumulates. So this is supposed to it's supposed to help the employee have days off in the event that they are unwell and they need to cover. So it is just the word sick off and sick leave. Employees and employers normally interpret them differently, but they are the same. Thank you.
Thanks for that clarity. So the off and the leave is actually a capture of time, but they all express the same issue. So on certificate of retirement, is that when someone has worked for you, now it will be below that where akienda, you write for them certificate of retirement. Now, sometimes people do maybe some things that are not right at the workplace, and they end up being suspended. They are suspended and they use some time outside as the investigation are going on. So Vivian is saying that Wakili was a bit far and from the mic, and maybe he didn't capture him well. So let me explain the difference again between sick off and sick leave. It is just a matter on issue. It just expresses the duration of time, because an off seems to be short. You went for 1-2 days, you had malaria, and maybe leave, we think it is longer. But all of them is that you are out of the workplace for a certain duration of time and you are not feeling well. So if you go for a whole, the law gives a maximum. It says if you are sick today, tomorrow, the other day, for the next 30, up to 30 days. Up to 30 days means from less plus 0, because it could just be a half day, from plus 0 all the way to 30 days. Here you are always supposed to have your maximum pay. But if it exceeds 30 days, that is the proposal, that now all the other subsequent 15 days, you will be paid half day. Remember the ruling yesterday of the court? It was pegged on a sick leave. This employee was sick for a very long time. And when the employer terminated him, he felt aggrieved and moved to the court. And while the court said that the employer has a right to terminate at that point, but it went further to say it should be humane, it should consider compassion and with care of the sick person. So the sick off and sick leave, it just expresses a matter of time. So I hope now you've heard what Wakili has told us well. I want to ask and pose a question now, and I want us to think about it in ourselves for some time. This person has done something that you perceive is not good. Maybe wameiba mafuta ya gari and umewashika wameiba mafuta ya gari, and they have proceeded to what is called suspension. You have suspended them, and they are out there as you are investigating. You are investigating. For how long should you investigate? For how long should this person stay out there? So this has been a gap that we are still collecting evidence. We are still thinking about it. Bado tunatafuta ule mtu ulizia mafuta. So this is what it says. Introducing investigative suspension of 14 days with full pay pending inquiry. So you have 14 days to put this person on suspension. Make sure within those 14 days, you have collected enough evidence that you need for further issues. That is a repeat. We have already seen about the wages, and we have seen that if you withhold people's income, now you will be charged 1 million shillings. Sorry for that, that is just a repetition of just what we have seen. Now, in our establishment, we collect a lot of personal data. This personal data, especially with the new world, has become very valuable. There are people who will do anything to trade with this data. And this law has come to to protect that. And this is what it says: protection of employees' personal data. It should be collected and it should be processed lawfully. So there should be a lawful procession. You should protect it from hackers, from all that. When you say protection of employee personal data and many other sensitive issues, it is upon the establishment to make sure it is secure. So you can see how up to date these new or these propositions are to the relevant world. Before we continue, I want to share with you an interesting story that will make you understand the next provision. This is a true story, but I'm going to hide the names of the organization. So one day, one of the employees of the organization took the organization to court. It was a manufacturing sector organization. And the employee won the case, and he was reinstated. The court found that it was wrongful termination. So the employer took the person back and obeyed the court order. But now in this particular factory, what used to happen is that workers used to sit outside. You report in the morning, you stand outside for a few minutes, and then you enter the factory. And then you do the work and come out in the evening. Every day, and they were in permanent employment. So the workers would go in and come out in the evening. So once this person who had gone to court reported to work on the first day, he walked in with the other workers and he stood outside. And the supervisor told him, we can give him a name. Let us call him Thompson. And the supervisor told him, Thompson, for you, your work will only be one. We are very happy to have you back. And we are happy that the court has reinstated you. But your work will be to sit on that stone. You see that stone near the door of the factory? Your work is only to sit on that stone, and we'll be paying you your full salary, your full benefit, your bonuses, but the only thing you will do for us is to sit on that stone. So Thompson will wake up every day, sit outside the factory, and just watch people go and work every day. The first day was amusing, second day amusing, 1 week not amusing, 1 month not amusing. He became very frustrated. With time, even people forgot he was sitting there. So one day they woke up and Thompson was not there anymore. Alijivuta tu polepole and he went. So what do I mean here? I've introduced to you through that story something called constructive dismissal. This is where you frustrate someone so much that they just go polepole on their own. Maybe you give them so many transfers. Today you take them to Kajiado, tomorrow to Kampala, tomorrow to your head office in Ethiopia, and they become distorted, their family lives become distorted, and they say, now I have to resign. Or you give them a workload that is so heavy. Or you come to them, you tell them, you've not replied to the email, this other email, and it becomes humanly impossible because you want that person to go. Now, that is having a new name. It is being called constructive dismissal. Now, the law wants to capture and they want to make a criminal offense, not a criminal offense, but an offense under the labor law for you to undertake constructive dismissal. Let's continue. We are just about to finish our presentation so that we can welcome a session of interaction. Now, in the current employment provision. If there is a dispute and at one point it cannot be solved at the workplace, we move the issue to the next level, until now we find ourselves at the labor office where we have who we call a conciliator. A conciliator has been appointed and his or her work is to listen to both parties, to listen to the employer and to listen to the worker and try to bring them together and avoid a very next level, which is the court. So they want to avoid that and they want to settle the issue at that point. Sometimes, even it is a court directive that they should go back and have some kind of conciliation. We have seen that. Now, there has been a legal provision that a third party advocates are not able to be parties in the proceedings at the labor office. The employer has been appointing somebody, and then the worker has been appointing and coming. Maybe the HR goes on behalf of the company, and the trade union goes on behalf of the worker. So they have been doing that within the framework and within the social dialogue, try amicably to solve the dispute. But now the new law is going to allow advocates to be able to be present as parties in the proceedings at the labor office. So that is just simply that now advocates can come in and be part of the labor issue. So ladies and gentlemen, we can clap for ourselves. We have finished that session, but it can be finished without hearing your voices and your comments. So feel free, both orally and written, to give us your feedback and also something you'd like clarity on this particular presentation. We can use the next 15-20 minutes to have a very nice, healthy discussion on the issues of the new bill. You can table this to me or to Wakili.
Hello. Now, yesterday there's a question that someone had placed on chat that unfortunately I did not see it until the meeting was over. The question was related to drunkenness and repeated drunkenness at work, how to deal with such employees. Now, the thing is, the provisions of the Employment Act regarding drunkenness sometimes confuse employers. So what happens is that you cannot dismiss an employee for being drunk alone, or for being or coming to work smelling of alcohol. That in itself is not a ground of dismissal. For an employee to warrant dismissal, you need to establish and prove that the employee was drunk to the extent that they are not able to perform their duties. So If you look at some industries, like in the airline industry, we have got specifically for pilots, we've got what is called a bottle to throttle policy. Bottle to throttle is the time duration between when the pilot has had the last drink and when he can get the controls of an aircraft. So this varies from airline to airline, but the minimum that I've ever heard of is 8 hours. So even after those 8 hours, there's a likelihood that the pilot will still have alcohol in the system, but a lot of it will have disintegrated and been absorbed into the body. So for an employer to prove that an employee was drunk to the extent that they are not able to perform their duties, they'll have to show that by means of testing the alcohol in their bodies. Alcohol in the human body is tested in two ways. It can be through the breath, the volume of alcohol in their breath, or it could be through a blood test. So, of course, it is if an employer carries out a test or a medical test on an employee without their consent, that medical test may be thrown out or may be disregarded by the court because the consent of the employee is extremely important. Now, I think we know that getting consent of an employee when they have been found drunk would be extremely difficult. So what employers are encouraged to do is they're encouraged to get the consent of the employee at the time when they are being employed, such that an employee signs and accepts that during the course of employment, they will be subjected to tests, sometimes randomly at the discretion of the employer. So that covers you in the event on the issue of consent. So it is very important to have consent of the employee when before a test is carried out. Thank you. Yeah, the employee might be able to work, but they are not willing. So that is something that needs to be considered before dismissal. I can see there's a question here online by Imelda Omariba. She says she has a question on kickoff from a staff for more days, sick off from a staff for more days in a year than the days worked. How should that issue be handled? Okay. Now, when it comes to sick off, of course, there's what the law provides for, and there's also what the company policy provides for. So at all times, a company policy should be within the law. So if, like the law provides for 30 days full pay, 15 days half pay, you cannot have a policy that provides for less sick of days than what is provided for by the law. So in situations where an employee, the days in a year that an employee has worked are less than the days that he's on sick of, an employer may be forced to make a decision to terminate this employee's employment on medical grounds because they appear that they are not able to work. And for an employer to terminate an employee's employment on medical grounds, they require to have a letter or a backup from a medical professional who can examine the employee and make that recommendation that the employee should be terminated on medical grounds. But at all times, as an employer, you should try your best to be humane, and you should not be very quick to reach the decision to terminate an employee on medical grounds. That should be a very last resort as an employer. Do you have any more questions or clarifications that you'd like to be put forward? Because I can see there are no questions in the chat either. I think I've answered all the chat. And ladies and gentlemen, if we do not have any more questions, I would beg to close this session at this time. And before I close, I would like to thank you all for your attention and for listening to us and for being with us for the last 3 days. We really appreciate the time you've taken. And I hope this course has been helpful to you. And if you feel that you have questions that you still need to be clarified on, I believe you've got contacts, and you can always feel free to bring them forth, and we will try our best to answer and to clear any inconsistencies or any questions that you may have. Thank you very much, ladies and gentlemen. I can see there's a question that has come from Andrita Moniki regarding whether you have any termination litigation matters on performance that have sailed through the court. No, termination on performance matters also go through the court. They've also been litigated on several. And there are times when employers have won, and there are times when employees have won. And all this is determined according, it's dependent upon procedure. What procedure did an employee follow? Did an employer follow before terminating an employee on account of performance? One is that, was the employee ever given a chance to improve their performance? And two, was the employee trained for that particular job? Because if you employed or picked an employee or promoted an employee into a role that made them incompetent to work, you will find yourself in trouble. Three, was the proper procedure followed in the event that chances to improve had been given to the employee? Was he given a fair hearing before termination? All these are factors that the court takes into consideration when they are ruling or making a decision regarding termination, performance-related termination. So there are several cases, just that I cannot remember any of them off right now, but there are cases where employers have won, and there are also cases where employees have won, depending on the procedure that was followed and whether this employee was ever given a chance to improve their performance. I hope I've answered your question, Amrita. So, Andrita has put in another question again, where she's asking, please comment on termination on gross misconduct and fair administrative justice. Now, fair administration is covered under Article 41 of our Constitution. This provides for fairness in all matters regarding employment, and not just termination. So, for a termination to stand, or in the event that it is challenged before a court of law, an employer would be tasked to prove that all their actions, they acted fairly. And fairly means that the employee was given a chance to defend themselves. The employee was also given opportunity. Chance to defend themselves also includes time to prepare. You cannot call an employee at 10 o'clock and tell them at 10:30, there's a disciplinary hearing, please come. The employee is supposed to be given ample time to prepare their defense. The employee is also, an employer should also take into consideration things like the employee's well-being. You cannot call an employee who is on sick off or who is on sick leave to abandon their sick leave and ask them to come for disciplinary hearing. That would not be deemed to be fair. So all fairness has to be observed, including them having a chance, being given a chance to bring along an employee of their choice at disciplinary hearing. So all fairness has to be observed. I hope I've answered your second question, Andrita. Okay. Andrita says she's comfortable with the answer that has been provided. Thank you very much. If there are no other questions, I think I will beg to stop there, and I will thank you again for taking your time to be with us for these sessions, and have a good afternoon, and God bless you all. Thank you very much.